Ready, start. Thus, the learned magistrate can make an inquiry in a particular proceeding other than a trial, but the material so collected would not be by a court during the course of an inquiry or a trial. Full stop. The conclusion, therefore, in short, is that in order to invoke the power under Section 319 CRPC, it is only a court of session or a court of magistrate performing the duties as a court under CRPC that can utilize the material before it for the purpose of the said section. Full stop. Section 319 CRPC allows the court to proceed against any person who is not an accused in a case before it. Full stop. Thus, the person against whom summons are issued in exercise of such powers, has to necessarily not be an accused already facing trial. Full stop. He can either be a person named in column 2 of the charge sheet filed under section 173 CRPC or a person whose name has been disclosed in any material before the court that is to be considered for the purpose of trying the offense, but not investigated. Full stop. He has to be a person whose complicity may be indicated and connected with the commission of the offense. Full stop. The legislature cannot be presumed to have imagined all the circumstances and, therefore, it is the duty of the court to give full effect to the words used by the legislature so as to encompass any situation which the court may have to tackle while proceeding to try an offense and not allow a person who deserves to be tried to go scot-free by being not arraigned in the trial in spite of the possibility of his complicity which can be gathered from the documents presented by the prosecution. Full stop. The court is the sole repository of justice and a duty is cast upon it to uphold the rule of law and, therefore, it will be inappropriate to deny the existence of such powers with the courts in our criminal justice system where it is not uncommon that the real accused, at times, get away by manipulating the investigating and slash are the prosecuting agency. Full stop. The desire to avoid trial is so strong that an accused makes efforts at times to get himself absolved even at the stage of investigation or inquiry, even though he may be connected with the commission of the offense. Full stop. Accordingly, we hold that the court can exercise the power under section 319 CRPC only after the trial proceeds and commences with the recording of the evidence and also in exceptional circumstances as explained here in above. Full stop. It is, therefore, clear that the word evidence close in section 319 CRPC means only such evidence as is made before the court, in relation to statements, and as produced before the court, in relation to documents. Full stop. It is only such evidence that can be taken into account by the magistrate or the court to decide whether the power under section 319 CRPC is to be exercised and not on the basis of material collected during the investigation. Full stop.